1A and 1B. पढ़िए अपना सब्स्टिट्यूशन पिटिशन पढ़िए। 2 जनरेशन चेंज होने के बाद आप सब्स्टिट्यूशन पिटिशन बताइए कहाँ है? एक ही आई है कि सब अलग अलग?
एक ही आई है।
किसका सब्स्टिट्यूशन चाहिए? तो सब्स्टिट्यूट द नेम ऑफ 1A 1B 3 4 5 6 and 7। 8 नंबर क्या हुआ? 8 नंबर जीवित है?
यस सर।
और 2 भी जीवित है? रेस्पोंडेंट नंबर 2 इज अलाइव और डेड?
डेड।
तो फिर 2 का तो सब्स्टिट्यूशन नहीं पाएगी। लखन लाल
यस सर।
अलाइव और डेड?
डेड।
कहाँ लिखे हैं रेस्पोंडेंट नंबर 2 को? 1A 1B 3 4 5 6 7।
3 में हो गया, क्वेश्चन नंबर 3 हो गया। लखन लाल डेड।
रेस्पोंडेंट नंबर 3 कैसे है लखन लाल? He was defendant number 3, but he would be respondent number 2 here, no? Because defendant number 1 was deleted
Yes,
initially, so he would be respondent number 2. ये respondent number 3 नहीं होगा ना, respondent number 2 होगा। Yes or no?
यस मैम।
एक तो कॉन्फर्मेशन डिले। अब कौन सा ये फाइल?
सब्स्टिट्यूशन फिर से नहीं आप कन्वर्जन डिले कर दो फिर से।
तो फाइल should I record that the respond number 8 is alive? आपका ये सब सारा सीक्वेंस गलत। As per the new cost title, ये एक सब ऊपर हो जाएगा। आप उसको एडिट करिए, ऐसे नहीं चलेगा। करिए। आप ये मत सोचिए 1984 का सेकेंड अपील रोज सुनेंगे आपको क्या लगा? एवरीडे वी विल हियर। आप इसको ठीक करिए। अभी इसका नया कॉस्ट टाइटल बनाए ना, उसके अनुसार आपको कॉपी दिए ना?
हाँ बिल्कुल।
सर और ये अभी तक आप अपलोड नहीं हुआ, इसलिए ये आप घर में लेके जा सकते हैं। इसमें सारा का सारा कॉस्ट एक्चुअली लिखा हुआ है, इसी के अनुसार जो है सारा ये रेस्पोंडेंट नंबर चेंज करिए आप प्रैक्टिस। देखिए सेकेंड अपील नंबर 88 ऑफ 1984 विद इन ब्रैकेट आर है ना,
यस
विद इन ब्रैकेट आर भी छुटा हुआ है। The learned counsel for the appellant has submitted that the appellant has been substituted by the earlier order dated 7/10/2025 and now the substituted appellant has filed petition being IA number 14039 of 2025 seeking substitution of respondent number 1A, 1B, 2, 3, 4, 5, 6. Namely, सबका नाम देंगे हैं, रश्मि देवी, सब्स्टिट्यूशन ऑफ रेस्पॉन्ड नंबर 2, 3 नहीं, ये लिखिएगा 1A, 1B, 2, 3, 4, 5 and 6. नेमली रश्मि देवी, चिंता देवी, सॉरी, नेमली रश्मि देवी, ओखैया देवी, लखनलाल, बुक्कर मियां, अब्दुल करीम, महावीर मेहतो, and फल्गुनेश्वर मेहतो। इसमें उनका रेस्पॉन्डेंट नंबर होगा, इसमें जो ऊपर लिखे हैं ना, 1A, 1B, 2, 3, 4, 5 and 8। अग्नू महतो और छोटू महतो जी, आप कैसे बोलिए, सभी मर गए है ना।
एक तो पहले
अग्नू महतो और छोटू महतो जीवित, जो 6 और 7 है वो दोनों जीवित है ना। इनको दीजिए तो सही। He submits that some error has crept in connection with mentioning the respondent numbers in IA number 14039 of 25, but the names have been correctly mentioned. अच्छा, respondent अग्नू में तो भी correct है, महावीर अग्नू का भी डेथ हुआ है, अग्नू का भी डेथ,
अग्नू का भी महावीर का भी,
हाँ अग्नू और महावीर का डेथ हुआ है, लेकिन उसका एक जो और है बीच में, छोटू की क्या नाम है,
छोटू है,
हाँ ये जीवित, इसके बारे में तो आप कहीं नहीं लिखे हैं कि इनका डेथ हुआ है, बताइए।
एक उनके अगेंस्ट में ही अवेट हुआ था वो।
अच्छा, उनके अगेंस्ट में
हाँ,
तो अवेट हो।
हाँ, उसी को
So far as respond number 8, namely
चुट्टू मार।
Chuttu Mato is concerned, the proceeding has already abated. तो ये respondent number, इसमें इसका respondent number 7 आ रहा है।
हाँ, 7 आ।
इसको 1, 2 कर दिया है, कैसे होगा? इसके अलावा तो कोई बच नहीं रहा, इसके अलावा कोई नहीं है। रेस्पोंडेंट नंबर 8 जो है फाल्गुनेश्वर महतो, सन ऑफ पंचू महतो, ये जीवित हैं?
नहीं,
ये भी डेथ कर गए हैं ना? यही तो, इन्हीं का ही तो अवेट हुआ, फाल्गुनेश्वर महतो का अवेट हुआ।
नहीं, उसे चुट्टू मार तक हुआ।
कहाँ से कर रहे हैं? कहाँ से बोल रहे हैं आप ये छुट्टू महतो का अवेट हुआ? इसका CNP वाले में तो रखा। नहीं, फाल्गुनेश्वर महतो के ही अगेंस्ट है। 9 रिस्पॉन्डेंट्स तो इसमें है ही नहीं, ओनली 8 रिस्पॉन्डेंट्स। फाल्गुनेश्वर महतो के ही अगेंस्ट है ना? There is no respondent number 9 in the proceedings because जब नोटिस भी इशू हुआ है तो respondent number 1 to 7 के ही अगेंस्ट में हुआ, 1 to 8 के ही अगेंस्ट में हुआ। There is no respondent number 9. आप इसको ठीक करिए। ठीक है, रेस्पोंडेंट नंबर 9 कोई नहीं है और फाल्गुनेश्वर के ही अगेंस्ट में बेट किया आपको। दीजिए करेक्शन। आइए मैं करेक्शन करती हूँ। करेक्शन करना है कि एफिडेविट फाइल करना
कर देते हैं।
ठीक है। The council seeks permission to make necessary corrections in the interlocutory applications. दोनों में हो गए, लिमिटेशन में भी लिखे होंगे। आप पढ़िए, उसके बाद ही उसमें होगा। वो फोटोकॉपी आपको वापस करेंगे, उसको लेकर नहीं जाएंगे। उसको कुछ एडिट करना पड़ेगा। RD लिखा हुआ है, केस का नंबर ही गलत लिखा हुआ है। हाँ वो रहेगा। और अभी हम नोटिस करेंगे, पहले उसको कर दीजिए, उसके बाद नोटिस। 12 बजे आ जाइए। उसकी आपको ज़रूरत पड़ेगी, पैसा नहीं करिए उसको, आपका रिक्वायरमेंट होगा उसको बताइए। ये जो कॉस्ट आइटम बनाए हैं ना, इसी के अनुसार करेक्शन करेंगे ना।
First case item 21 CMP 498 of 2012.
ठीक है, इसका करेक्टेड रिकॉर्ड नहीं आया है फर्स्ट अपील का,
आ गया।
आ गया दिखाइए। Appellant absent है तो ऐसे डिसमिस कर देते हैं, that is better.
Because of their laches leadership, the amount was in lakhs. Right now, the amount has went to crores. Every year, 15% of interest has been accrued. पता नहीं क्यों पे कर देते तो अभी तक 2 रुपया में काम हो जाता।
ये वाला किस इलाके से अरेज करता है?
This is arising from 9 of 2019.
अपीलांट है नहीं है? अभी तो थे, आप हैं?
अभी तो थे तो निकला बाहर।
तो हम उनके पास चले
नहीं,
जाएं, डीएपी कर देंगे इसको हम,
बुला लेते
और जीवन में कभी रेस्टोर नहीं करेंगे। बुलाइए उनको,
बोल दिए।
The original land user has also died. This is again.
ये वाले 9 से रिलेटेड है ना, सब तो सेम ऑर्डर है।
हाँ सब same order है leadership 9 of 90 का है. And the order was passed by Honorable Justice Ambai Iqbal.
नाम लेने की तो कोई जरूरत ही नहीं है।
I'm very sorry. I'm very sorry. Lordship.
मेन फाइल कौन सा मान ये इसके मेरे को ऑर्डर इसका इंप्यून ऑर्डर देखिए और सबका इंप्यून ऑर्डर देखिए। फर्स्ट अपील का रिकॉर्ड इसका जो फर्स्ट अपील है 220 का फर्स्ट अपील है, सेम ऑर्डर है ना।
Annexure 3 ML जिसमें कि फाइनल ऑर्डर पास हुआ है रिड्यूसिंग द अमाउंट ऑफ रुपीज 2000 टू 1400।
सुनिए एक सेकंड, ये जो ऑर्डर है, ये जो इंप्यून ऑर्डर है, इसी इंप्यून ऑर्डर से आपका 3 केस ऑलरेडी डिसमिस हो चुका है। दिखाइए, दिस इज द इंप्यून ऑर्डर और द फर्स्ट अपील। इनको तो सब चीज दिखाना पड़ता है, देखिए इनको कोई मतलब ही नहीं है देखने से।
यस मैडम,
दिखाइए, देखिए, यू जस्ट हैव अ लुक एट इट।
नहीं ये इसको रेफर कर रहे थे मैडम, Annexure 3 जो है
सेम है ना,
सेम है।
तो फिर इसको क्यों रेस्टोर कराना है? Why do you want this matter to be restored?
And because my lord separate first appeal has been filed against this judgment.
So,
This
separate first appeals have been filed and first appeals has been rejected.
first appeal has been rejected.
Yes.
But in pursuance of land ILA case number 9 of 90, my lord, we have preferred an appeal, the first appeal, my lord, upon the
Yes.
final judgment.
Yes.
And The first appeal being 123 of 2006, my lord, is still pending for adjudication for which CMP is filed for its restoration, my lord.
123.
123.
That 123 has been dismissed on the point of non-prosecution.
Non-prosecution and for restoration of the same,
What
my
is
lord.
the CMP number?
CMP number, my lord, 490.
498.
498, my lord. And
123 का ना है
My
ये
lord.
और 124 का क्या किया?
124 का, my lord, that file is not.
Yes, it is come. This is what I am showing you. आप समझ ही नहीं रहे
हम समझ
आप
रहे हैं।
समझना नहीं है या समझना नहीं चाहते
मैं
हैं,
लोग
वो
ये
समझ
इनका
नहीं।
स्टेटमेंट था कि 124, 25, 26 जो है ये सेम जजमेंट के खिलाफ जो है डिपार्टमेंट अपील में आया था और उसका भी सीएमपी जो है वो डिसमिस हो गया है। इनका ये कहना है। बट सो फार एज माय लॉर्ड एलआर केस नंबर 9 ऑफ 90, माय लॉर्ड।
आप हमको एक बात बताइए, ऑल एलआर केसेस हैव बीन डिस्पोज्ड ऑफ बाय द कॉमन जज।
कॉमन जज।
So how the other case is different from this?
Because my lord, the order is not passed on merit, my lord. The CMP, by virtue of the dismissal of CMP, the first appeal has got dismissed, my lord.
Maybe it has not been passed on merits, but just tell us.
But in this case, my lord,
I am not satisfied with the cause shown for restoration. That would be sufficient.
my lord, delay already इसमें कंडोन हो गया है।
इससे क्या होगा delay से?
और रिस्पोंडेंट नंबर 6 स्टेट ऑफ बिहार को नोटिस भी हो गया है, वो अपीयर भी हो गया है।
We are not interested. We are not interested. Arising out of the same land acquisition proceedings, a batch of cases were filed, right? And arising out of the same judgment, देखिए आपका LR केस नंबर कौन सा 9 है?
9 है भाई।
8 के अगेंस्ट में डिसमिस हो चुका है,
भाई
राइट? 8 के अगेंस्ट में डिसमिस हुआ है इन FA नंबर,
FA number 124 of 2007.
ये है 124 ऑफ 2007,
Yes, my lordship.
ठीक है? ये डिसमिस हो चुका है, दैट ऑर्डर हैज अटेन्ड फाइनलिटी, और ये वाला 9 है, और बाकी कौन सा है?
बाकी 11 of 2019, FA number 125 of 2007.
125 of 07, ये भी डिसमिस हो गया।
Then after FA number 13 of 90,
हाँ।
FA number 126 of 2007,
126 of 07,
FA number 12 of 90, FA number 127 of 2007.
127 of 2007, और ये LR केस नंबर 14 ऑफ 90 के अगेंस्ट में नहीं किया है इन्होंने फर्स्ट अपील।
No.
किया है कि नहीं किया है?
जरूर किया
कुछ
होगा।
पता नहीं है ना आपको? You don't have any information. पूछेंगे कोई भी चीज तो नहीं पता।
My lord, all the first appeal had not been dismissed on merit, my lord.
May not have been dismissed. But the point remains that arising out of the same land acquisition proceedings, ultimately you will give compensation to the neighbor at a different rate. How do you justify this? How do you justify this? Tell me. How do you justify this?
My lord, that appeal is not associated, my lord, personally for our office, my lord. That's why we are not able to say.
सरकार एक है कि सरकार भी अलग अलग करती है?
सरकार तो एक ही है।
या आपके काउंसिल्स के सरकार अलग अलग है क्या? पॉसिबल नहीं हो सकता ना ऐसे। We are not inclined to restore this. No, we will not restore it. I am not inclined to restore this agreement.
My lord, CMP में जितना भी डिफिकल्टी का my lord सब उसमें सारा कुछ जो है डिले कंडोन हो गया है, रिस्पोंडिंग को नोटिस हो गया है my lord।
इससे क्या होगा?
और ये CMP अलाउ होने से फर्स्ट अपील my lord रिस्टोर हो जाएगा और मेरिट पर जो भी ऑर्डर होता my lord।
The final judgment itself says that all the exhibits and the witnesses were examined by from both the sides, and then after the final judgment was passed. So what is remaining behind that? That 1400 also will not be considered by the department.
आप हमको सिर्फ इतना बता दीजिए, कि दूसरे वाले फर्स्ट अपील में आप क्या अलग कर सकते हैं? हाउ विल यू जस्टिफाई डिफरेंट compensation when it comes to other appeals? How will you justify that?
Lord says the Honorable High Court did not go into the merit of the case, Your Lordship. So everything would be the new fact for which I want to rely my Lord. The new order, my Lord, is under challenge in the first appeal, my Lord. And I humbly pray, my Lord, to hear the matter on merits, and after that, Your Lordship, if any of the orders by passed by this Honorable Court, my Lord, we are obliged to follow.
और आप ऑर्डर ही सुनिए। CAP नंबर 498 of 25।
मैं लोग एक चीज और प्लेस कर देते हैं वो आपको एक आईडी फाइल किया था भाई रिगार्डिंग द लायबिलिटी द which authority will have to pay.
I will not bother about it.
मैं लोग
We are not bothered about it. We are only concerned with the restoration. Who will pay and who will not pay. You go and satisfy the executive. ऑर्डर डेटेड 10/10/25 को पूरा ही ठीक है।
May I point out one thing? In that order dated 10/10/25, the IA which was considered, that is also right now it's showing pending. Your Ladyship has considered the IA of the substitution and has awaited opposite party number 2 from this
Yes.
proceedings.
Yes.
So right now also it is pending.
No, IA is closed. In order dated 10/10/25 passed in this case is voted as under. It has been recorded in order dated in the aforesaid order that the proceeding has abated with respect to opposite party number 2 also. और पहले किसके against में
1 and
abate
3.
किया? The proceeding against 1 and opposite party number 1 and 3 has already abated by order dated 19/7/2025. Consequently, the present proceeding for restoration stands abated as against opposite party number 1, 2 and 3. The opposite party number 1 to 4 were all sons of late Huzafti South. The awardee in this case.
Yes, the original awardee.
The original awardee in this case. Moreover, from the perusal of the records of FA number 125 of 2007, it is apparent that the same was filed in connection with LR case number 11 of 1990 and was ultimately dismissed for default. Way back as on 7/12/2010. FA number 124 of 2007 was dismissed for default way back as on 7/12/2010, which was filed in connection with LR case number 8 of 1990. And FA number, record FA
125, 126.
125. FA number 125. Wait, हो गया. 1, ये तो 11. This is FA number 124 was in connection with LR number 8 of 1990.
Yes, Your Worship.
All these cases were arising out of land acquisition case number 7 of 75/76.
Yes, Your Worship.
ये भी सेम ही ऑर्डर से DLT हुआ है ना.
Yes, Your Worship.
Was also dismissed on 7/12. ये 3 रिकॉर्ड हमको नहीं दिखेगा. ये 123 है. अच्छा ये इसका है. ये इसका 126. 126 was in connection with LR case number
13 of 19.
13 of 1990. The records of the case reveal that no steps were taken for restoration of those matters, and the present case arises out of the 123 से arise करता है.
Yes, Your Worship.
LR case number 9 of 1990.
Yes, Your Worship.
Arising out of same land acquisition case number 7 of 75.
Yes, Your Worship.
The impugned order in the present case, the impugned order in FA number 123 of 27, which is sought to be restored through the present CAP number 498 of 2012, was passed analogously with other cases arising out of the same land acquisition case number 7 of
75, 76.
75/76. The learned counsel for the applicant has submitted that the other analogous cases were not decided on merits, and therefore the present case be treated differently, and the first appeal be restored and the same be decided on merits. It is not in dispute that the awardee, the original awardee in the present, in the LR case number 9 of 1990, where चारों थे.
No, Lordship. 1990, चारों थे. After the death of the original awardee, Hujjat Sahu, they were been substituted.
the original awardee was
Pujati Sahu.
Pujati Sahu, and the opposite party number 1 to 4 are the legal heirs and successors of Pujati.
Pujati Sahu.
The proceeding has already awaited as against opposite party number 1 to 3.
1, 2, 3.
In view of the aforesaid facts and circumstances, this court is not inclined to allow this application for restitution, which is hereby discussed.
Lordship, may I pray one thing? If Lordship gives a direction to the executing court to...
I will not give any
I'm
direction.
sorry. I know that I have to file in another
You
way.
have to take your steps in the execution.
Thank
जब
you.
अवेट ही कर दिया 3 के अगेंस्ट में, तो अब बचा ही क्या? अब रेस्टोर करके कैसे क्या होगा? नहीं हो सकता।
Executing court थोड़ा execute कर दे जल्दी Lordship बस.
आप जाइए।
Otherwise, मैं हो चुका हूँ.
I think to second appeal 522 of 1991.
Yes, appellant.
Lordship, IA number 13866 of 2025 has been filed for the deletion of respondent number 1, small a, Roman number 2, who has died on 2016. Her legal heirs has already been mentioned in the present case, as already been made party in the case as respondent number 1.
Any objection, appellant? I number 13866 of 2025 in second appeal number 522 of 1991 to that effect. The learned counsel for the respondent has submitted that the interlocutory application has been filed for deletion of the name of respondent number 1 with bracket A with bracket Roman 1, namely Jharkhand Divya, who has expired way back in the year 2016. She submits that the name, her legal heirs are already on record. Counsel for the appellant has no objection for the prayer for deletion. Considering the submissions made, IA number 13866 of 25 is hereby allowed. The name of respondent number 1 in bracket A in bracket Roman 1, namely Lottery Divya, is permitted to be deleted from the cost item. The learned counsel for the respondents is directed to carry out the necessary corrections in the memo of appeal. She is 1 within bracket.
Bracket small a, bracket small 1.
1. ये एकदम टॉप पर है. Is directed to delete the name of property from the cost item during the procedure. चलिए अब बहस करिए.
Yes, another
And
yes,
substantial question of law क्या है?
इसमें एक और 8/8/25 को ऑर्डर था कि रेस्टोरेंट 2 के लिए सर्टिफिकेट लीगल एयर्स के लिए अप्लाई करने का, नोटिस फाइल करने का, बट से वाज नॉट फाइल, बट इट प्रेजेंटेड करेक्टेड, नॉट फाइल, से वाज डिसमिस्ड सिंस
तो हो ही गया जिसमें सब क्या करना. बहुत अच्छी बात.
टाइम फॉर
क्या केस है? नहीं ये सब नहीं चलेगा ना. 91 का पटना का केस है, ये सब नहीं चलेगा. इतना नेग्लिजेंस हमको तो बर्दाश्त ही नहीं हो सकता. अब आप बहस करिए मेरी. You will see what is going on. You argue the case on merit, नहीं तो हम dismiss कर देंगे for default. फिर अगला 40 साल तक रेस्टोर नहीं होगा. नहीं कुछ नहीं हम कुछ नहीं आपका. ऑर्डर करते हैं, नोटिस करते हैं, हम कंप्लायंस नहीं करते हैं, कुछ नहीं सुनेंगे. It has already been dismissed. The matter is over. बताइए. मैं मेरिट पे बेस करके सब्सटेंशियल क्वेश्चन ऑफ लॉ बना है इसमें? बना ही होगा ना सेकेंड अपील है, बताइए कौन सा है? Which is that order by which substantial question of law has been framed?
19/12
19/12?
एक 90
19.
involving this appeal as to whether a judgment or degree passed by the court below can be sustained because they did not attach the proper presumption in favor of the appellate as provided under the section 16 of the Hindu Adoption.
बताइए इतना छोटा सा substantial question of law.
I was instructed by my colleague to
क्या करने मुझे?
that 1 week time they were given.
Rejected. एक rejection 4 बार नहीं हो सकता. You argue your case.
Last chance or
क्या last chance? 91 के केस में आपको क्या last chance देंगे?
only 1 week.
नहीं. I don't know. मतलब आपके निकले पे आपको कैसा ट्रीट करते हैं, लेकिन हम तो आपको बढ़िया से नहीं समझ सकते. We can't do anything. हो सकता है आपका सब्सटेंशियल क्वेश्चन ऑफ लॉ आपके अगेंस्ट में ही आंसर हो जाए, तो उसको सब्स्टिट्यूट करके क्या करिए?
I will see.
कुछ नहीं, आप पहले बेस्ट
See. Not fully prepared for this since he
I will dismiss it right away.
presumes
I will record that you are not fully prepared and dismiss it. आपको मजाक लग रहा है क्या? ड्राइंग रूम में बैठे हैं आप?
he thinks that sometimes we dismiss therefore we will take proper step
No steps. I will say that you are not prepared.
for restoration.
I will say that you are not prepared. When you say that you are not prepared, I will record that you are not prepared. और ये सारा recorded proceeding है. और इस sentence को हम withdraw नहीं करेंगे. Correct?
And what is correct, but as prayed by letter on behalf of my learned counsel.
Rejected. Prayer is rejected. सूट कब का है?
91.
नहीं सूट से
73 का है. आपका जन्म हो गया था 73 में? Were you born? 73 का सूट का कहानी है, 91 का 2 अप्रैल. हम एकदम नहीं अटेंड करेंगे. आपको जो बहस करना है करिए, नहीं करना माने लिख ही देते हैं that you are not.
एक अपील ऑलरेडी डिसमिस हो चुका है सेम जजमेंट 521
सेम जजमेंट.
सेम जजमेंट
कहाँ है वो जजमेंट?
ये साथ में अटैच है.
वो ऑर्डर शीट पे मिली है और ऑर्डर 8/25 में भी है. ऑफिस डायरेक्टर टू प्लेस द रिकॉर्ड सेकंड एविडेंस फीचर इज ऑलरेडी अवेटेड.
ओरिजिनल प्लेंटिफ वाज द डॉटर.
9/22. सेकंड में 522 का ऑर्डर.
उसमें कौन अपीलेंट?
ये
अराइजिंग ऑफ द सेम
सेम जजमेंट.
तो दो अपील क्यों फाइल?
दो सेट्स. एक क्लेम करते हैं कि आई वाज अडॉप्टेड सन, अदर क्लेम करते हैं कि नहीं इनको हेयर डॉटर को नहीं मिलेगा शेयर इन द.
तो ये जो दूसरा केस हुआ
हाँ.
डिसाइड मेरिट पे हुआ?
नहीं, इट वाज abated because they have not filed any petition since they are just lingering the matter.
Second of 5/22 to have ordered 8/25 last. Which is said to have been awaited by Dr. Art No by second appeal.
इसमें कोई sole appellant, Bakun Rai had died. Right? यहाँ पे Bakun Rai ही appellant है.
नहीं,
इस केस में
इस केस में नहीं,
इसमें नहीं,
इसमें
कौन appellant?
इसमें सावित्री जी ओरिजिनल थी,
नहीं, सावित्री देवी नहीं थी।
तो सब्स्टिट्यूटेड।
हाँ, सावित्री भी सब्स्टिट्यूटेड है। मुरलीधर, both were brothers.
और Bakun Rai इसमें है respondent.
Yes.
उनका substitution
Respondent
हो
number
चुका
3
है. Bakun Rai का substitution हुआ है इसमें.
बाद में डाले हैं यहाँ, हो गया।
और इन्हीं के लीगल ईयर्स पर हम लोग बोले थे क्या नोटिस
नहीं, ये नहीं, रेस्पोंडेंट नंबर 2 के लीगल ईयर्स।
यही तो रेस्पॉन्ड नंबर
हाँ, उन्हीं के लीगल ईयर्स के सब्स्टिट्यूशन जो डिसमिस नहीं लिया, डिसमिस को डिफॉल्ट हो गया।
बहुत अच्छा,
बहुत स्टेप लिए थे मैंने।
बहुत अच्छा। क्या हुआ फिर डीएफडी कैसे हो गया?
उसमें केस नंबर 521 लिख दिए और इसकी पार्टी का नाम फाइल है विद इन टाइम, बट एड्रेस एंड द केस नंबर वाज रॉन्गली।
नहीं सब कहानी हमने सुनी। What is your status? You are relying on adoption.
I will not go through the detail, but he informed
कोई
on
बात
that.
नहीं, आप ही बताइए जिसको
Detail.
बहस करना तो फिर आप किस लिए खड़े हैं? आप साइड पे बैठ जाइए, बताइए।
इंस्ट्रक्शन नहीं मिला है।
इंस्ट्रक्शन नहीं मिला है, यही लिख के डिस्कस कर देते हैं। जितना जितना बात आप बोलेंगे उतना उतना बात लिख के हम डिस्कस करेंगे।
इन्फॉर्म किए हुए हैं लेकिन आए नहीं।
They are not interested. डिस्कस करें।
Yes.
कुछ नहीं। Essay number 522 of 1991.
2 वीक का टाइम दिया था
कोई चीज़ का टाइम नहीं।
प्रॉपर
एक के साथ तो ऑलरेडी डिस्कस हो चुका है। This appeal has been filed against the judgment dated 19/9/1991 within bracket decree dated 28/9/1991 passed by learned additional district judge Devkar in title appeal number 14 of 1977/9 of 1991 affirming the judgment and decree of second additional subject Devkar dated 15/12/1976 within bracket dated 16/12/1976 passed in title suit number 31 of 1973/60 of 1976. This appeal was admitted for final hearing by framing substantial question of law while order dated 19/12/1991 inverted comma whether the judgment and decree passed by the court below can be sustained because they did not attach the presumption in favor of the appellant as provided under section 16 of the Hindu Adoption Act. Question mark? Inverted comma close. The records reveal that by the order dated 9/10/2025 Revised order dated 8/8/2025. Revised order dated 9/6/2025. ऐसा लिखिए, order dated 19/6/2025 reads as follows. The required notices were not properly filed, and thereafter order dated 8/8/2025 has been passed, giving 2 weeks time to the counsel for the appellant to comply the order dated 19/6/25 with regard to legal years of respondent number 2. Within the preemptive time, the order dated 8/8/25 reads as follows. In spite of such opportunity, the order was not complied and the appeal has to be dismissed for non-compliance of order dated 8/8/2025 as against respondent number, as against the legal years of respondent number 2, that is against respondent number 2, 1 and 2 to be bracket 1 and 3. The learned counsel for the appellant has submitted that he has got no instructions in the matter from the appellants, correct? No instructions?
So,
The learned counsel for the respondent has submitted that arising out of the same judgment, he has got no instructions in the matter to, or from the appellants, and he is otherwise also not ready to argue the matter. The learned counsel for the respondents has submitted that arising out of the same judgment, one second appeal being essay number 521 of 1991 within bracket P was filed, and on account of date of vacant right, who was the defendant in the case, the second appeal stood abated. By the order dated 8/9/2020. The learned counsel has submitted that in the present case, the respondent number 2 is vacant trial, and this appeal has again stood dismissed as against respondent number 2 on account, as against the legal years of respondent number 2, that is respondent number 2, 1, 2, 3, on account of non-compliance of order dated 8/8/2025. It submits that nothing survives in this appeal. since the appellant has no instructions to argue the case and otherwise also he is not ready with the matter. And the fact remains that the appeal has stood dismissed as against the defendant.
Yes. Both the appellants, both the appeal, they were the defendants.
Backbone to die.
And Bekun Rai was also one of the defendants, and this Murlidhar Singh, who is the present appellant, he was also one of the defendants.
Sole defendant नहीं थे.
नहीं. And even the substantial question has been well discussed in para 17 and 18 of the appellate court judgment.
और भी किसी के अगेंस्ट अबिट हुआ है?
नहीं.
In view of the submissions of the counsel for the appellant that he has no instructions and is not ready to argue the case, this appeal is dismissed as not pressed.
Action 3, second appeal 280 of 2004.
Ladyship, in the last order, the notices were supposed to be sent by both process. That has been delivered.
Respond number 1 has appeared.
Yes,
With
sir.
respect to respond number 4, the proceeding has abated.
Yes.
Respond number 5 to 9 and 11. Notice has been served. Respond number 5 to 9 and 11. Notices have been served. कौन बच गया इसमें?
इसमें
Who's left?
three. On the last response number 3, legal heirs were added in action.
On behalf of them, I have already filed Wakalat Namar.
So that IA has to be allowed. Is
Yes,
there
you are
any
saying
pending?
that I will be allowed.
Where is that IA number?
IA number is 2818 and 2807.
128.
07 is for setting aside the amendment and substitution.
So there is I have filed one joint reply document. There is an inordinate delay of more than 4 years 6 months from the date of knowledge and 15 years from the date of death of respondent number 3.
The reason confirmation I have explained from 21 my wife was suffering from cancer and 24 she expired. So the reasonable explanation to that is there.
From 21 it is there.
20 documents have been from 22 years, but since it's a cancer disease that was there and the appellant are villagers, agriculturists, and he's a person that lacks, he's basically he signs through his thumb.
petition do you want to place first? There are two petitions.
12807.
Okay, let us see the explanation.
Of delay. Delays in my petition 281. It is
Yes, what is the explanation?
para 4. Para 4, page 4. May I read?
Yes.
Para 4. That the applicant could not file a formal petition for substitution immediately for the reason that applicant lacks legal acumen survived by daily agriculture activity. Applicant is a villager and was not aware of the proceeding in the case. He was also looking after his wife's medical needs and she was battling the cancer and renal background. Died in the year 22 January 2024. And that he was looking after her wife and unfortunately could not save her life. By order dated 21 March 2022, this Honorable Court directed the applicant to file substitution petition. The applicant was unable to comply within a time reason explained above. The second appeal was subsequently restored by dated 21/2024. CMP order is already there. By 12 January.
In the CMP, there were the substituted legal years were.
Yes, it was there.
No,
It was there. Several IEs I filed.
Where is the order of substitution?
Sir, it is.
This is the first time when the notice was issued by this Honorable Court, Your Worship.
Yes, you will page 36 CMP.
Yes.
It is page IA 1370 because while once its second appeal dismissed and I file CMP, in the CMP it gets defected. This party has been noticed by their respondent number 3 expired. So this party needs to be made part in the CMP as well. So that IA was filed to that effect. IA 11378 of 2023. It is at page 36 of that CMP order.
Yes.
And it is that this application by paying for deleting the name of the
What is the
suppliant.
name of respondent number 3?
Joseph.
Sorry?
Joseph.
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 It has been noticed to the court Supriya Nikhan, Joseph Ekar and Elvis Ekar death as the petitioner want to delete their name from the cause title. Considering the matter, I am inclined to according to the same server that necessary getting cause title of the petitioner at the risk of the petitioner.
So you have done it at the risk of the petition. You never prayed for substitution.
It is
At the stage of restoration, it was allowed at your risk. Very good. So your risk, that risk is on.
that it will be allowing my second appeal.
We will not allow this substitution. You should have insisted that the notice should do and you will file your substitution petition. You should have moved against those persons. You simply prayed for deletion. And the second appeal stood restored. Now you want substitution here. How is it possible? The legal years were required to be substituted at the stage of restoration also, no? They might have got an opportunity to oppose, right? And what about these two persons, Supriyan Ikka and Elvis Ikka? You wanted deletion of all these three persons. They are all dead.
So, yes, Your Lordship. Elvis Ekar are dead.
They are all dead.
Dead.
Yes.
They are still party here in this proceeding.
No, Lordship. Supriyan died already issueless, and his brother is already on record. Therefore, Lordship, in the last order, Lordship has passed an order to delete his name. Respondent number so far, respondent number 2 is concerned, and Lordship so far, respondent number 4 is concerned. Lordship has already passed an order of abatement against respondent number 4.
That is always
Yes, Albish.
already abated.
Yes, Lordship. Lordship has passed the order in the last date.
And Supriya deleted.
Yes, sir.
It stood abated.
Yes, sir.
As per this order itself, it is abated.
Yes,
So,
but
the restoration stood abated. How will I substitute here? The restoration stood abated. How the second appeal will be substituted? How in the second appeal they will be substituted?
that restoration, in the restoration,
If the restoration is abated, then how the substitution will be allowed here in second appeal?
it was, second appeal was only for the dismiss because of the non-compliance or something.
अब आपको समझ में नहीं आएगा. लिखिए second appeal number 283 of 2004 with IA number 12818 of 2024 and IA number 12807 2024 नहीं of 20 IA number 24 है कि 25?
25.
ये 24 लिखे हुए हैं. कोई नहीं सकेगा आपको उसे. पार नहीं पा सक रहे हैं. IA number 12818 of 2025 and IA number 12807 of 2025. The learned counsel for the appellant has submitted that this petition has been filed for substitution of respondent number 3 Joseph Ekka. And there is a delay of
From the date of knowledge is more than 4 years, 6 months.
and there is a delay of
more than 4 years, 6 months.
delay of 15 years.
From date of death of respondent.
From the date of death, the delay is 15 years. From the date of death, already 15 years, 6 months, and 10 years.
10 days.
10 days has expired on the date of filing of the petition for substitution. The date of death, as disclosed in the petition, is 26/9/2009. 9 से 15 years हो गया.
Yes, sir.
Abatement हुआ.
Abated.
हाँ. Is shown as 26/9/2009. IA number 12818 is a prayer for confirmation of delay, and IA number 12807 of 25 is a prayer for setting aside abatement and substitution. The learned counsel for the respondents has opposed the prayer and has submitted that the second appeal stood dismissed for default.
Yes.
And thereafter, a petition for restoration was filed. It was CMP number 851 of 2022. And in the said petition, the fact that 3 persons have expired, namely Supriya Ekka, Joseph Ekka, and Elbes Ekka, was brought on record, and a prayer was made through IA number 11378 of 2023 to delete their name. They were respondent number 2, 3, and 4 in the state CAD. The learned counsel has submitted that the prayer for deletion was allowed at the risk of the petitioners seeking restoration. And it has been specifically mentioned in the order itself that appeal against dependent number 2, 3 and 4, that is Supriya Ikka, Joseph Ikka and Albis Ikka stood abated. He submits that once the restoration was abated, there is, in connection with the aforesaid 3 persons, there is no question of any substitution in the substituents. The learned counsel has further submitted that Supriya Ikka had died issueless, and therefore by an order of this court in the second appeal, her name has been deleted. And so far as Albis Ikka is concerned, in the present proceedings also, it has been recorded that the proceeding has abated as against Albis Ikka, as against the legal years of Albis Ikka. ये कौन सा ऑर्डर से हुआ सुप्रिया का?
But last order it was.
Also 15 September.
15 September.
He refers to the order dated 15th of September 2025. The learned counsel has submitted that. Otherwise also there is no explanation for delay in filing the petition for substitution. The learned counsel for the appellant has submitted that once the second appeal was restored, the petition for substitution was made. Correct?
My medical grounds were.
He has also submitted that the wife of the petitioner appellant was suffering from cancer and documents in connection with
Are available from
her suffering from cancer are available from the year 2022, which has been placed on record. But there is no explanation so far as the period prior to 2022 is concerned.
prior to 22, and I don't have the explanation why the party was not made in the restoration. Which
He has got nothing to say as to why the respondent number 3 was not substituted in the CM, whereby the second appeal was. After hearing the learned counsel for the parties and upon going through the order passed in restoration being CMP number 851 of 2022, this court has categorically observed that the name of Supriya Ikka, Joseph Ikka and Albis Ikka were deleted on account of the death at the risk of the appellant who was petitioner in the same case. And it has been further observed in paragraph 3 that on 21/3/2022, pre-emptory time was granted to substitute them, but they were not substituted, and the case was dismissed for non-compliance of the order. Such order was passed in the second appeal itself. This court is of the view that no steps for substitution was carried out in the restoration application, and the restoration was allowed, the deletion of the name was allowed at the risk of the petitioners. Otherwise also there is no cogent explanation given in the interlocutory application seeking enormous delay in filing the petition for substitution. In such circumstances, both the interlocutory applications are dismissed. अब बताइए क्या बोलना? What else?
Your Worship, only part that in the CMP, it was only for the purpose of restoration.
At the stage of restoration also the legal errors were required to be brought on. Why don't you understand this? You can't have a cakewalk in restoration ex parte or anything. In that case you just prayed for deletion of them. Why a prayer for deletion? They were to be substituted. At least addition of party should have been there. That without hearing them this restoration also cannot be allowed. But you never took any steps. Right? So restoration was the deletion was at your risk. You never allowed them to become party in the restoration application. They will not restore it.
Then it will be affecting this second appeal because
It will affect.
Yes, Lordship.
It will certainly affect. There is no doubt on that. It will affect.
The sale deed is joint, which is under challenge.
And as it is against one of them, it is
Yes,
already
already.
abated, with which you are not concerned.
Relief are common because it's a joint sale deed.
Now, when will you argue the case against the remaining defendants? When will you argue the case against the remaining defendants?
the remaining defendant will be.
When will you argue the case against remaining defendants?
Second week.
As per the office note dated 27/8/2013, the respondent number 3 was reported dead by the process server. Three and 4 both were reported dead by the process server. में ही आ गया था रिकॉर्ड में.
On that basis, the order dated 10/12/20 was passed, Lordship. On the basis of that service report. An appellant came to know about the death of respondents on 10/12/20 itself.
and on that basis an order was passed on 10/12/2020. रेस्टोरेशन में लीगल ईयर्स को नहीं नोटिस करिएगा तो आपका सेकंड अपील में नहीं हो सकता। क्या सर ठीक बोल रहे हैं ना? रेस्टोरेशन में नोटिस जरूरी है ना, उसके बिना नहीं हो सकता। राइट हैज क्रिस्टलाइज इन देयर फेवर, इट इज नॉट परमिसिबल। रीट पिटीशन का रेस्टोरेशन और सेकंड अपील का रेस्टोरेशन में बहुत फर्क है। You should not have filed an application for deletion. You should have filed an application for substitution. चलिए, कब करना बताइए?
November.
थर्ड वीक को?
November.
At the request of the counsel for the appellant, the matter is directed to be posted on 17th of November under the heading of final disposal.
Item 4, second appeal 336 of 2004, along with item 5.
Discuss and give for substitution of legal heirs of appellant number 1 surplus to during corona period. There is below
1, 2.
Yes. I filed the wakalatnama of the legal heirs also. There is delay in that file also filed petition under order 22
किसका वकालतनामा फाइल?
सब legal heirs का जो
आपको कोई ऑब्जेक्शन?
कोई ऑब्जेक्शन नहीं है, लेकिन इसमें ड्यूल आई एम अपेयरिंग ऑन बिहाफ ऑफ द रेस्पोंडेंट नंबर सब्स्टिट्यूटेड रेस्पोंडेंट नंबर 28B2K and out of 28B2K 28B and 28D has died.
उसका substitution हो गया
28B and
D.
they have not filed the petition 28A तो एक बार substitute
But
करेंगे
28A was because her legal heir is on the record, so his name has been deleted. So
28B and
B and D. 28B and D.
not today is informing this fact, let it be then next week.
I will
I'll
supply
file
the
it.
detail.
Yes, if you supply the details, I can file by day after tomorrow. I can file it.
Kamdev Mahato and Vishnu Mahato.
If it may be adjourned only for tomorrow, party has come, I will file affidavit to that effect. We can supply the legal heirs.
आपके पास है लीगल?
हाँ, I will supply.
आपके पास वकालतनामा भी है सबका?
हाँ, वकालत भी
मिल गया है।
हम फाइल कर देते हैं.
ऐसे नंबर 336 of 2020. The learned counsel for the respondent has submitted that respondent number 2B and 2D
2D.
have expired. He undertakes to provide the name of legal heirs and successors of respondent number 2B and 2D to the counsel for the appellant during the proceeding.
Yes.
The learned counsel submits that he shall take appropriate steps and the matter be posted to the appellant.
Yes, that I file. She has
You
to
also have
file.
also to
File. She has to file. Even respondent number 1 का legal heirs का इनको file करना अभी तक नहीं किया है.
डिटेल्स लेकर आज आए हैं वो भी
Respondent number?
इनके अपील में respondent number 1 जो अपीलेंट है इस अपील में उनका भी legal heirs ही नहीं.
हम लीडरशिप आज उनको बुलाए हैं तो उसको भी हम फाइल कर देंगे.
Let it be.
अपील में जो respondent है, दो अपील है ना?
हाँ, next अपील में जो respondent number 1 है उनका डेथ हो गया है, उनका सब्स्टिट्यूशन ये नहीं किया
हाँ,
है.
वो लॉर्डशिप हम कर देंगे और लॉर्डशिप से डिटेल्स से लेते हैं लॉर्डशिप.
ये वाला ऑर्डर पास करेंगे 336 है ना?
हाँ,
अभी
yes.
जो ऑर्डर.
हाँ, that I will.
इसमें किसका डेथ हो गया?
इसमें रेस्पोंडेंट 1 का लॉर्डशिप को फाइल करना था. लॉर्डशिप आज वो लोग आए हैं तो लॉर्डशिप हम सर से डिटेल्स ले लेते हैं
हम कर देंगे और शायद उसको भी फाइल और इनको भी
परसों रखी रहे आप कर दीजिए, आपको जो करना है, आपको जो करना है कर दीजिए, परसों तो रखी रहे, आप यहाँ से परमिशन लेके तो फाइल कर सकते,
ठीक है
ठीक है?
Yes.
आप दे दीजिए उनको सारा,
Yes.
स्पेलिंग ठीक से लिखिए,
Yes.
स्पेलिंग में एरर होने से दिक्कत क्या है tomorrow?
6.
Item 16, second April 16 of 2022.
आपके नाम मिस्टर अमर कुमार सिन्हा कोर्ट नहीं आ रहे, उनका रोज यहाँ एडजर्नमेंट रिक्वेस्ट आता है एवरी डे फॉर लास्ट 1 वीक, दूसरे कोर्ट के लिए आ रहे हैं क्या?
I'm sorry.
Yes, every day there is an adjournment request.
By way of last.
No, why way of last chance? No, you see, no. Last time also there was an adjournment request. Then? No, I don't. Is he not coming to the court?
Yes.
Then? For last 1 week I am seeing in all the cases, his cases are being adjourned on personal grounds. He has personal grounds only for this court. Then? I will not adjourn it. No.
It's not possible.
एक केस के लिए मेरा तबीयत ठीक रहेगा और एक केस के लिए तबीयत खराब रहेगा, तो ऐसा नहीं चलेगा, नहीं चलेगा, एकदम नहीं चलेगा, ये चीज सही नहीं है। रोज आता है उनकी तरफ से, रोज 3-4 केसेस का एडजर्नमेंट रिक्वेस्ट आता है। दिस इज, ये कोई मजाक है क्या? This is adjournment request is not acceptable. I will not accept. I will not adjourn this case. I will not. नहीं होगा, एडजर्नमेंट करेंगे कम से कम, नहीं तो 50,000 रुपए कॉस्ट लगेगा। देखिए मिस्टर अमर कुमार सिन्हा से रेगुलर बेसिस पर एडजर्नमेंट रिक्वेस्ट आता है, and this is a second adjournment request, and he has come to the court. It is not that he has not.
He has come, Millard. What has happened in this case, Millard?
I am on the adjournment request. What has happened, we'll see later.
No, Millard, this is actually, Millard, I have to assist, Millard. I have argued this matter, Millard, at the time of admission. And Millard, for last, Millard, due to matters of personal difficulty, due to problem of Millard, I am not concentrating the all.
You have not given adjournment request.
No, उनका भी नाम था, मेरा भी था. तो Millard, I was not able to come, Millard, but I have come, Millard. And I have requested कि इसमें other side को भी हम request रोहित side को के
हम इसको adjourn नहीं करेंगे, because the request has come from his end, and he is already there in the court. We will not adjourn this case. Either you argue or you don't argue.
Millard, हम argue कर देंगे तो Millard हम start कर देते हैं.
नहीं ये क्या मजाक है क्या? start कर देते हैं?
The only difficulty, Millard.
There is no difficulty.
Millard, difficulty.
This is not proper. For
But
last every day you see my WhatsApp messages I get from my coaches. Every day. It is not only one day. For last 1 week, all his cases, एक हफ्ता हो गया हमारे, समीर जी. For last 1 week, all his cases are adjourned on personal ground.
Millard, हम regular appear कर रहे हैं. Millard, kindly see.
नहीं आपके appearance से कोई मतलब नहीं.
Millard, kindly see the admission order by which Millard I have argued, Millard.
I might have argued.
Millard, kindly see.
So you argue now. You have argued enough.
Yes, Millard, my submission, only one submission, Millard. Only one submission, Millard. I never sought and seek any adjournment on false.
The adjournment request has not come from your end.
Millard, due to my because I was ready with the file, Millard, and due to my personal eyes problem, I am not able to concentrate those. Millard, 1928 registered it. I have also communicated due to my personal difficulty, Millard.
No, that is not the request.
Millard, since I was not able to come today also, Millard, that's why I have not given. Millard, only pray, Millard.
No.
Otherwise, I always argue, Millard.
No, you always argue, but the request was made on account of one counsel. right? Essay number 16 of 2022. An adjournment request has been forwarded by the advocate on record, Mr. Amar Kumar Sinha. On the earlier occasion also, the matter was adjourned on 6/10/2025 at his request. It has been informed that Mr. Amar Kumar Sinha has entered the court. Mr. Sandeep Verma has appeared and has submitted that at the time of admission of the case on 21/7/2025, he had assisted this court, and today, on account of his personal difficulty, he is not able to argue the case. क्या रीजन दिया है एडजर्नमेंट रिक्वेस्ट में? कहाँ है आप? क्यों नहीं लगाते हैं? रीजन क्या दिया बताइए? पर्सनल डिफिकल्टी। मिस्टर अमर कुमार सिंह, कब करना है बताइए? बिना कॉस्ट के हम एडजर्न नहीं करें। आप बताइए आपको कब?
मैडम हम ओपनिंग डे में कर देंगे मैडम, 29 में।
कोई बात नहीं, बिना कॉस्ट के एडजर्न नहीं होगा। बिना कॉस्ट के एडजर्न नहीं होगा। इवन आई बेग अपॉलॉजी। बिना कॉस्ट के एडजर्नमेंट नहीं होगा। बताइए कब करना है? खाली डेट बता दीजिए।
29
At his request, the matter is adjourned and is directed to be posted on 29th of October. Subject to payment of cost of rupees 10,000 rupees to Advocate Clerk Association. The receipt regarding submission of cost should be filed by Friday, that is 17th of October, failing which this appeal shall stand dismissed without reference to it.
30 कर दिया जाए, 30 कर दिया।
हाँ?
30 38 कर दिया जाए।
अच्छा 30 30 तारीख।
Item 17, second appeal 274 of 2023.
Yes, ma'am.
The last order was a review on the substantial question. The substantial question was whether basket purchase in respect of relic granted without notice to the concerned realty, and the second question was whether in absence of any inquiry report of the circle inspector as required under Rule 5, basket purchase issued to respondent 1 is without jurisdiction. Yes, sir.
This second appeal is by the plaintiff appellant. Your Lordship, may already my learned friend has read the substantial question of law, or whether basket purchase in respect of rayats granted without notice to the concerned rayat, and whether in absence of any inquiry report of the circle inspector as required under Rule 5 of the basket purchase issued to respondent money is without jurisdiction. Your Lordship, on the factual aspect, I am very short now. I am not in The suit was filed for declaration that the circle officer Hiranpur Nepal issued patta under BPPST Act to the defendant number 1 or defendant number 4, nor he could issue nor the defendants acquired title. Now it relates to the first question. The second one, the jurisdiction of CO. Now it relates to Bihar Privileged Persons Homestead Tenancy Act, where it has been provided that 3 conditions are to be seen. Number 1, the land which is to be settled, to whom it is to be settled, is a landless person. And secondly, the before settlement notice is to be issued to the landholder, the originally landholder, for whose land is to be settled. Thirdly, there must be an inquiry, and that inquiry cannot be conducted by a person not less than circle inspector. This is rule.
Where is the issue regarding basket purchase?
Number.
Framed by the court.
Yes. Lordship may kindly come to.
Where is the issues framed by the learned?
Yes. Now, Your Lordship may kindly come to the trial court judgment.
Issue number 9.
Issues are at page 68, running page 68, inner page 16. My learned page is correct. Issue number 9. Whether the patta public basket parcha dated 11th February 1975 issued by.
I'm not getting it. It is at what page?
Page number 68 to running page and inner page 16 of the trial court judgment. Trial court judgment.
16, 16.
16. Para 4. Para 4. These are the issues. I'm turning over the next page.
It's
Issue
a
number.
landlord-tenant relationship.
That I am also explaining. Now, issue number 9. Whether the patta public basket parcha dated 11th February 1975 issued by Anchal Vikari Hiranpur in favor of Muhammad Hatim, husband of defendant number 1, and father of defendant number 2 and 3, and Muslim Mia defendant number 4, regarding suit property described and scheduled in the plan at antedated and forged. So this is the only issue framed with regard to basket. Now you also may kindly come to, so for finding part is concerned, trial court judgment, page number 109, running page, 109, para 17, para 17.
Running page 109 is.
Para 17.
Match नहीं करता है अभी. Para page 109 is para 23.
Inner page you go. Inner page 57. 57. Page 57. Inner page.
Back जाना होगा. 57.
57. 109 हुजूर हाथ से लिखे हुए हैं फॉर्म.
ठीक है.
वो हम लोग लिखा क्योंकि एपेलेट कोर्ट का जजमेंट से शुरू किए हैं. ये लॉर्डशिप जस्टिस पैरा 14 का इशू नंबर 6, 7 and 9. All the 3 issues have been quoted. Then your lordship may kindly come to the relevant part, para 20. At page running page 63, inner page 63. Yes, sir. Inner page 20, paragraph 20 is inner page 64, 116. Most probably handwritten below is 116 and type copy is 64. Admittedly, the suit property was purchased land by Bandhu Mia, father-in-law of the plaintiff. Plaintiff is the appellant. Plaint para 3, written statement para 11. This is an admitted question. It is case of the plaintiff where Bandhu Mia died about 35 years ago, and just few months after his death, his heirs and legal representatives partitioned his all properties, including the suit property, by metes and bounds, and so the suit property fell in the share of his elder son, namely Muhammad Ganori Mia, husband of the plaintiff. That is para 5 of the plaintiff. It is defense of the defendants that Bandhu died long ago, much before 35 years as alleged by the plaintiff, and that no partition took place between the heirs and successors of Bandhu Mia. So the suit property was not partitioned and it remained intact with Bandhu Mia as self-acquired property, as it was never given as share to Muhammad Ganori Mia, husband of the plaintiff. That after purchase, Bandhu Mia gave the suit property to his daughter Haliman Bibi, Abidan Bibi, for her residence, who gave the suit property along with dwelling house to her daughter Rasidan Bibi, who resided with peaceful enjoyment, possession and title since 1965, as purchased by her mother Habiban Bibi, written statement para 13.
So, according to the written statement also, this Bandhu Mia did not
Yes,
die
it-
issueless.
No. They admit that he died leaving behind the husband of this plaintiff, but they deny that there had been any partition. So they claim that Bandhu Mia in his lifetime alleged to have allowed the mother of the defendant to reside. There was no partition, and it did not fall into the share of the husband of the plaintiff as claimed by the plaintiff.
Bandhu, his daughter means Habiban Bibi is
Not
whose
daughter.
daughter?
No. Habiban Bibi is daughter of one Rasidan Bibi. Habiban Bibi is mother of Rasidan Bibi, the defendant.
How is Habiban Bibi related to Bandhu Mia?
That is, she is not related.
Not
She is
related.
stranger.
Stranger.
Now it is, yes, stranger.
No, stranger.
Yes, I am just coming to that.
She is the daughter of Bandhu Mia, Habiban Bibi, or Rasidan Bibi is the daughter of Habiban.
Rasidan
She is the daughter also.
Rasidan is daughter of Habiban. Now the case made out by the in the written statement is that the Bandhu Mia alleged to have allowed Habiban Bibi to reside,
A stranger.
according to us. She has no right to the property, according to us. Now, my lord, this is their case. It is to be proved by them. Now, regarding
You are the
partition,
plaintiff, no?
I have said it is.
This is the question of settlement through that act comes only
Now
when
what-
there is no legal here.
Yes,
Two daughters,
the
two sons.
landless person can get, he should be a stranger,
Landless person can
not
get.
in the family members. Otherwise, if
Just
this
a
is the
moment, sir. Family members will get by inheritance.
inheritance. Now, this
Landless
is one
person
case.
will get the property only when there is no legal here.
Yes.
Yes.
Otherwise, under that VPT,
Cannot be settled.
it cannot be settled.
Therefore,
So therefore, there is an
therefore,
inquiry.
two alternative plea taken by the defendants. One plea they have taken that Habiban Bibi, being daughter of Bandhu Mia, got the land from her mother Bandhu Mia. This is one part. And
written
second,
statement दिखाई ऐसा नहीं आपका ये कहानी
जी।
दिखाई plain written statement.
In that case, based upon that the partition was held between the family members.
No, as I
Our
remember-
case is not that there was no family partition.
As I remember, subject to what you have to say, under this act, the property, anybody's property cannot be settled.
No.
If somebody dies issueless and there are
No,
no,
he is not the issue. Two daughters, two sons.
so therefore it cannot be subject matter of settlement.
Yes, obviously.
It
But it
cannot
has
be
been
subject
settled,
matter
they
of
are relying
settlement.
their title on settlement.
No. They
Who
are
is
saying
making settlement?
they are relying upon the point of partition among the family members.
Let us come to the root. Under
Yes.
this act, can there be a settlement if there is a legal heir to the property?
Yes. Only one point, approximately one point. But they are saying that the partition portion of the suit property was lying in the share of the plaintiff. Our case, there is no partition. there was no partition among the family members.
Okay, so
So Lord, their plea would say, if there was any partition, Lord, and as per the Muslim law, Lord, the settled principle, that each and every co-seller should have been got some of the shares, Lord. But he has not been successful, Lord, to produce any of the documentary evidence or any of the fact evidence for the court below that either each and either of the seller below has got any of the piece of land. But see, he is willing to say that only Lord, Ganoria is the only person Lord, who has got the entire share. How this is possible?
see, please do not argue in this manner. We have framed certain questions.
Yes, I am not on that.
You just, we will see that what is the result of that consequence of that question of law. Do you have any objection to question of law?
No.
You don't have any objection.
No.
Now we have to see whether the settlement has been done in accordance with it.
But now, for this
For
purpose,
that purpose, there are two pre-requirements. One is that the property should not belong to anybody. क्या बोलते हैं उसको?
हुजूर एक्ट देखा जा सकता है.
Like,
BPPS है. बिहार प्रिविलेज पर्सन होम स्ट्रीट टेनेंसी. लॉसी मैकेनिसी फर्स्ट ऑफ
40 डिक्लेयर होने के बाद ही ना होगा सेटलमेंट. 40 डिक्लेयर होने के पहले सेटलमेंट होता है.
नहीं.
40 डिक्लेयर हुआ है क्या?
वो एक तरफ उस सेटलमेंट का मांग रहा पिताजी से हमको मिला है और दूसरा तरफ सेटल पर्चा से मांग रहा है.
नहीं वो इंदिरा पारा 39 ऑफ द अपीलेट को
पैरा 2 है. पहले एक्ट देख लिया जाए.
व्हाट इज द फाइंडिंग्स?
पहले हम लोग एक्ट ही देखते हैं ना, क्या क्या रिक्वायरमेंट. बिना 40 डिक्लेयर हुए कोई सेटलमेंट होता है क्या?
इनका कहना है हुजूर कि ये
उनका कहना नहीं, एक्ट का कहना बताइए. हम सुनेंगे ना आपको. ऐसा नहीं है कि अभी तो रिकॉर्ड पूरा देख के सुनेंगे और हम तो प्लेन रिटन स्टेटमेंट से सुनना शुरू करते हैं. ऐसे खाली नहीं सुनते.
यस.
तो आप हमको ये बताइए, अंडर द प्रोविजन ऑफ बिहार प्रिविलेज पर्सन्स होमस्टेड टेनेंसी एक्ट, कैन देयर बी एनी सेटलमेंट without any declaration that the property is bought? Bought means that there is nobody to claim that property. Can it be possible? आप सेटलमेंट क्लेम कर रहे हैं ना अंडर दिस एक्ट.
ये सेटलमेंट क्लेम नहीं है. मेरा तो पार्टीशन का क्लेम ये है. इनके पार्टीशन को ट्रेस करना चाह रहा हूं.
तो फिर ये फौत का ये सब कहानी इसका प्रेयर क्या है? इनका प्रेयर क्या है? देखिए
इससे
पहले प्रेयर से शुरू करते हैं.
अपीलेट कोर्ट का यूनिवर्सिटी में कहने मिला ये
अगर आप बोल रहे हैं कि फौत का कोई इशू ही नहीं है तब तो आपको बहुत सीरियस ऑब्जेक्शन होना चाहिए इस सब्सटेंशियल क्वेश्चन ऑफ लॉ में. यू आर नॉट ऑब्जेक्टिंग.
पारा 39 ऑफ द अपीलेट कोर्ट जजमेंट. ये बासगीत पर्चा हुजूर जो बोल रहे हैं उससे बासगीत पर्चा के लोग उससे वी हैव बीन इन कंटीन्यूअस पोजीशन लोड फॉर मोर देन 60 इयर्स.
एडवर्स पोजीशन नहीं क्लेम कर रहे हैं ना.
ये एडवर्स पोजीशन नहीं.
बासगीत पर्चा आपको इशू होता है ओनली विद रिस्पेक्ट टू अ प्रॉपर्टी which is not owned or inherited by anybody. दूसरा का प्रॉपर्टी में तो आपको नहीं मिल जाएगा ना बास्केट पर्चा.
तो ये तो है नहीं जो पिक्चर में ना भी. But on that occasion of time, he was not present in the entire of the conversion.
He did not possess.
The land is possessed by me, Lord. The land is possessed by me.
No.
But
possessed by you by virtue of basket पर्चा.
नहीं, बासगीत पर्चा का मकसद ये है कि इंदिरा आवास योजना का घर बनाने के लिए हमको दिया गया.
वो तो किसी का भी घर प्रॉपर्टी दे देंगे ना इंदिरा आवास बनाने के लिए.
नहीं, प्रॉपर्टी तो हमको दिया गया. जीवन बीवी जो है
वही तो चैलेंज में है ना. दैट इज अंडर चैलेंज.
जीवन बीवी जो है उनको वो जमीन जो दिया गया है उसके बाद कंटिन्यूअस उनका पोजीशन है. वो रेंट रिसीट भी है उसका. और जो बासगीत पर्चा का है टेकिंग प्ले अबाउट
ऐसी बात नहीं समझ आ रही. कोई आदमी मर गया और उसके बाद क्या हुआ, सरकार ने उसकी जमीन पर कर दिया सेटलमेंट. चलेगा क्या? इफ ही डाइज विदाउट एनी लीगल हियर, दैट इज देयर इज अ प्रोसेस टू डिक्लेयर द प्रॉपर्टी एज फॉर. करेक्ट? यस और नो?
इफ ही डाइज इशू यस.
राइट?
यस.
देयर इज अ प्रोसेस ऑफ डिक्लेयरिंग द प्रॉपर्टी एज फॉर and then only any settlement can be made. Because this inquiry has to be done whether there are any legal heirs or not.
Yes, it has come with him. So he had 2 sons, 2 daughters.
You see the very fact, if he has 2 sons, 2 daughters, they have a right to inherit.
Yes, obviously, yes.
Then how the property can be settled under this act?
Lots of mechanical settlement. One question I am putting upon myself. But see about 4 legal heirs. What's the Bandhungia had 4 legal children, 2 sons and 2 daughters. What's the how it is possible? If there was any partition was done between the 4 sellers, what's the
Forget about the partition. You forget irrespective of any partition. Let's assume that you are opposing that there was no partition.
yes, obviously.
You are opposing that there is no
Yes.
partition. But still there are legal heirs and successors.
Only one person.
एक ही
Only
काफी
one
है।
person.
एक ही काफी है। ज़्यादा legal heirs की जरूरत
He
नहीं
is claiming, but we are in possession.
You are in possession.
Yes.
Very good. You are in
One-
possession by
1 to
virtue
4.
of issuance of basket purchase.
No. Basket purchase was issued later on. Which the land was transferred by Bandhu Mia to his daughter Hadivan Bibi. And thereafter, Hadivan Bibi transferred his land to Rashidan Bibi, which is her daughter. And thereafter, the land, the property was inherited by Hatim Mia Miller. Hatim Mia Miller, the son of Rashidan Bibi, and one Miller, wife of Hatim Mia, Ashira Beva Miller.
इसका नोट बनाइए, ऐसे नहीं होगा, आप अपनी तरफ से नोट बनाइए। कैसे
अच्छी नहीं, हम कल ही पढ़ पाएंगे।
ऐसे कैसे होगा?
इसको कल रख दीजिए, हम भी
कल
शॉर्ट सिनॉप्सिस बना
2 दिन का टाइम हमको दिया जाओ, 2 दिन के बाद
शॉर्ट सिनॉप्सिस बना
क्योंकि थोड़ा सा फैक्ट्स में
बहुत clumsy facts है।
क्लमजी फैक्ट्स है, आप
जी।
इसका नोट्स बनाइए।
जी बहुत जरूरी है।
फॉर द लॉट्स ऑफ टाइम कंसीडरेशन हम अपीलेट कोर्ट का केवल थोड़ा सा उनको दिखा देना चाहते हैं। पारा 30 ओनली 1 मिनट। उससे इशू नंबर 9 में उससे डिसाइडेड इन फेवर ऑफ द से डिफेंडेंट रिस्पोंडेंट और द सेम इशू हैज आल्सो बीन डिस्कस्ड।
लेकिन छुट्टी के पहले तो ये हो नहीं पाएगा, ठीक है?
जी।
आप इसका सिनॉप्सिस जो भी बनाना है, आप दे दीजिए।
एग्जिबिट बी हुजूर बास्केट पर्चा है जिसको ये लोग रिलाय किए हैं, उसी पर क्लेम किए हैं टाइटल। एक 2 किस्म का क्लेम है इनका। एक है कि मेरा दादाजी मैंने पिताजी दिए माँ को और माँ दिए बेटी को, कोई लिखित में कोई दरखास्त ये नहीं है। दूसरा है इनका क्लेम है कि एग्जिबिट बी बास्केट पर्चा से हमको मिला, इसलिए हुजूर ये क्वेश्चन था। दिस इज द रीजन फॉर इशू नंबर 9 एंड द अपीलेट कोर्ट सेज
आप
देयर इज
इसका नोट बना लीजिए, ओपनिंग में रखते हैं 29 को, लेकिन नोट आप पहले दे
जी।
ठीक है?
You have to look for the regular names or something
बताइए।
about 5 मिनट।
कब बताइए
फर्स्ट वीक
आप?
ऑफ नवंबर को कर दिया जाए। फर्स्ट वीक ऑफ नवंबर।
The hearing in this case has commenced. Learned counsel for the parties have submitted that on account of the clumsy facts involved in this case, short synopsis may be required. They undertake to furnish short synopsis of arguments along with the judgments which they seek to rely upon by 16th of October, 17 तारीख तक,
अक्टूबर
Yes.
by 17th of October. Post this case for further hearing on
17 अक्टूबर। अच्छा हम लोग फाइल कर
file करें।
ठीक।
Post this case for
ठीक।
further hearing on 3rd November। और बाद में बताइए आपको कहीं जाना है बाहर।
I have to live for the legal note.
बताइए कब रख- आप choose your date।
After 5 or 6 November.
On 10th of November।
Oh yes.
On 10th of November।
Yes.
For final disposal।
Yes।
Final
Yeah।
disposal में ही होगा। ये थोड़ा ध्यान में रखेंगे कि सेटलमेंट मतलब अगर इशूलेस किसी का डेथ होता है तो दैट इज द प्रोसीजर इन रिट्स में बहुत सारे देखते हैं। फॉर्थ बिना डिक्लेयर हुए ऐसा सेटलमेंट नहीं।
What's if there is no any legal is what is present on the canvas? But here is the case is different. The legal is are present on the
We will
canvas.
see, we will see,
Yes.
we will see। एक चीज और देखिएगा, ये जो सेटलमेंट होता है इसका कोई इंटरनल रेमेडीज भी होता है एक्ट में,
Yes.
है ना?
Item 18, first appeal 136 of 2024.
This is the case
सर्वर
Dr.
एक्टिव होगी।
हाँ फिर अपील हो गया इसमें मुझे याद करेंगे the trial court lordship, one of the plaintiff died. I'm the plaintiff, one of the plaintiff, and we prepared an appeal. but he was not substituted in the trial court. By Lordship's order, Lordship, they have been substituted. They have notice have been given to them. They have also.
At the stage of trial, they were not substituted. You are the defendant?
Yes, no, we are plaintiff. Both are the plaintiff. His father died. Their father died. He was not substituted by the other plaintiff, that is me. The issue on the last occasion, Lordship has, while allowing my IA, Lordship has observed that since it is a continuation of appeal, and therefore it has to be seen whether the case is to be remanded or not, or the matter can be decided at the appellate stage. And second point, Lordship, I have filed one IA for an additional evidence, Lordship, which is if they want, they can file reply to the same.
Who is for the defendant?
Defendants are respondent. Mr. Satish Kishri is appearing. Last.
Where is he? He was appearing for all
Yes,
the
yes. The contesting defendants.
ये बाकी defendants भी तो जरूरी है ना, पार्टी है तो. He is appealing for whom?
I think Lordship is appearing for 3 to 7, perhaps Lordship. Because 8 and 9, the newly added respondents are.
And you are representing 8 and 9. 3 to 7 he is representing.
Yes, that is what I.
Okay. State is not the contesting. State is not the contesting.
State is here. They did not file the WS nor they contested in the trial court. State is.
That's right. So one of the defendants had expired. One of the plaintiff had expired.
Plaintiff had expired, Lordship. In the appellate stage, Lordship, they have been substituted. And that was the issue, Lordship.
They have been substituted or they have been added as one?
Added as respondents.
We have not substituted.
Yes, added. That was my application. That was my application.
Then under such circumstances, if it has to be remanded, then they will have the opportunity to get substituted.
One thing, Lordship, yes, that is what my argument was. And since, Lordship, in one of the cases, I got a query from the court, and that was a very right query. Since the decree isn't required to be amended, because decree has been prepared, Lordship, against a dead person. Unless and until that decree is amended, that can be done only by the trial. That is only a limited question, and on that, after amending the decree, after hearing the matter, because they have been added party here, the same direction can be given for the trial.
No, they may have some right.
Yes. Therefore, I am submitting.
Right.
I am not saying that it is only correction.
Evidence.
After hearing the parties, then they will file.
They file their written statement or they
Yes.
not file their
Look, they are the plaintiff.
They are the plaintiff. Sorry. You are the plaintiff.
Yes.
When did they die? At the time of evidence or post evidence?
Before, Lordship, between the two, Lordship.
So they also have a right to
Yes,
read
yes.
evidence. Then under such circumstances, not only hearing, they have a right to read evidence also.
Everything. De novo trial if the court wants it.
Is there any conflict of interest?
No, not at all. Because whatever I'll get, he will get.
You are brothers.
Yes, Lordship.
So when you are brothers, you don't take any step at the time.
That is true, Lordship. That is very true. That is, I have also informed to my client. That was a wrong committed by the part of the
you cannot say
plaintiff also and also.
Having lost.
Yes.
Now you say that he was. You cannot say.
No,
that.
I am not saying that. Therefore, Lordship, only technical thing is there whether decree can sustain which is against a dead person in an appellate state. That is only. Otherwise, Lordship can also continue since the interest is safe. I am also here to protect their interest. If I have an interest, then they also have an interest. Because in some of the cases.
Can the plaintiff take advantage of their own wrong?
No,
by
not
taking any steps for substitution.
उसमें हुआ क्या है कि 2-3 judgments of the Honorable Supreme Court is there. In that, Lordship, same situation was there.
No, it is a different situation because in those cases the defendant by the appellant.
Plaintiff भी हम दिखा देंगे. Plaintiff भी है वहाँ गलती हुआ कोर्ट माना कि ठीक है नहीं हो पाया because the suit and appeal prolongs for a long time. Sometimes it happens, and therefore in some of the cases the matter was heard by the concerned court after accepting them as party, because the rights are being protected by the appellate court also. Nothing is to be done by them. And in some of the cases, Lordship, the matter was remanded, and that is absolutely at the discretion of the Honorable Court. Because since that can be observed in the judgment part.
The matter is for land acquisition.
Lordship, the matter was actually for the right title interest of the land, and wherein Lordship the compensation has been given to the defendants. They are claiming their own right, and their right was settled, and on that basis, Lordship, the compensation was given. I was saying that in 1956, the ancestors of those defendants had settled the land in my favor. We also got the rent receipts. Several cases were fought, and on that basis, Lordship, this
was a reference case.
It was not a reference case, Lordship. It is a proper title suit has been filed after the compensation was paid to them.
So there is a procedure for.
Section 30 order was also, yes, Section 30 was also dismissed. We preferred Section 30, that was also dismissed. Therefore, Lordship, we came to the court directly for declaring our right title and interest, and consequently thereupon directing the state for making compensation to us.
Was it maintainable in this one? Do you have a remedy through Section 30?
Section 30 remedy
now
was...
you file a separate suit after having lost under Section 30.
Because those documents are not there. Somewhere I read somewhere, but neither those things have been exhibited. Because both the parties have exhibited very limited documents that Lordship will kindly find from.
You are talking about land acquisition case.
Lordship.
You are talking about preparation of the award.
Yes. We are talking about the award which was wrongly given to them.
In case the award is wrongly given to them, you have a remedy under Section 30.
Yes, Section 30 remedy under the old Act. Old Act.
Yes,
perhaps somewhere it is there, Lordship.
Yes. इसमें respondents को हुआ है notice?
हाँ, respondents notice को वो appear भी किए हैं, contest भी किए हैं. Last occasion में भी their name are also appearing. They also filed rejoinder to my.
Respond number 3 to 7.
Yes.
Where are they?
इसमें एक आईए Lordship फाइल की है. उस पॉइंट पे अगर इनको टाइम दे दिया जाए रिस्पांस के लिए और छुट्टी के बाद रख दिया. आईए फॉर एडिशनल एविडेंस. बस इतने ही है. मैटर ऑफ डिसाइड होगा एट द टाइम ऑफ फाइनल हियरिंग. बट इफ दे वांट टू फाइल Lordship,
क्या एडिशनल?
ये एडिशनल एविडेंस है जो 1947 में एक सूट हुआ था, wherein Lordship, my predecessor in interest, he got a decree from the थोड़ा clumsy fact है. ये जमींदार का केस था. एक जमींदार जो बड़े जमींदार थे.
उसको पहले क्यों नहीं प्रोड्यूस किए?
ट्रायल कोर्ट में हुजूर वहाँ तो सब्स्टिट्यूट नहीं किए हुजूर, तो डॉक्यूमेंट क्या प्रोड्यूस करेंगे?
और सेक्शन 30 का तो आप रेमेडी अवेल नहीं किए.
हम एक बार देख लेंगे उसको भी हम एनालाइज कर लेंगे. समवेयर आई हैड रेड दैट उसका, बट दैट डॉक्यूमेंट हैज नॉट बीन एग्जीक्यूटेड.
और खाली डिक्री लगाए, जजमेंट क्यों नहीं लगाए?
कौन दोनों चीज लगा होगा तो डिफेक्ट पर आ जाएगा.
नहीं
ऐसा हो नहीं सकता.
आप देखिए ना क्या लगाए.
करेक्शन हो गया और पता
नहीं. अब देखिए
हमारे
एडिशनल एविडेंस में क्या लगाए हैं.
अच्छा हाँ, वो डिग्री है, दैट इज द डिग्री. वहां से क्लैरिफाई करेंगे वो डिग्री से ही होगा. हाँ नहीं डिग्री है चूंकि जजमेंट उसका मिल नहीं रहा है. डिग्री इज सर्टिफाइड कॉपी और जजमेंट रखते नहीं है. पुराना केस का सिर्फ डिग्री ही रहता है, उसको अभी हम ऑब्टेन किए.
ऐसा कैसे होता है? जजमेंट
1947 में हुजूर उसके बाद का सिर्फ डिग्री ही रहता है. व्हाट आई हैव इंक्वायर्ड. ये इससे तो क्लैरिफाई हो जाएगा. 2-4 लाइन है, आई जस्ट एक्सप्लेन.
नहीं देखिए इस तरह से ना आपको टाइटल सूट का ये जजमेंट लिखी आप हम फर्स्ट अपील स्टेज में इस तरह का
नहीं ठीक है हुजूर. दैट मे बी कंसीडर्ड, नॉट मे नॉट बी कंसीडर्ड. दैट इज डिफरेंट एस्पेक्ट. हम इसको लगाए हैं शायद मेरे कुछ काम आ जाए ऑन दैट बेसिस. Because since my predecessor in interest had got a decree that the whatever has been done by his father is not binding upon him, because after the death of the father the other brothers got some right और वो लोग ही अपने claim करके यहाँ पे ले लिए. And the elder person who became the जमींदार subsequently has settled the entire land in our favor.
नहीं ये सिर्फ ऐसा डिग्री का बात नहीं है.
How कोई डिग्री हुजूर?
Right, you are writing so many things on that basis. Right? It is not just.
वो हम उससे
It is
नहीं
not just an issue.
नहीं हम अपने प्लेंट में जो है एवरमेंट उसी को हम नोट किए. It is not out of the record. We have stated in the plaint also.
वो प्लेट आपने.
प्लेंट से लिए वो वही हम लिखे.
उसका टैक्सी सूट का डिग्री क्यों नहीं पास फाइल? Why didn't you file?
और पैराग्राफ 4 देखा जाए. We have taken everything from the plaint और कहीं से नहीं लिए. It's mostly stated in some title suit number such and such was filed by the plaintiff appellant, and it has been stated in paragraph 3 of the plaint that Jagannath Shahi Manki, who was the karta of the family, and the elder son Diwan Shahi Manki held the estate of village Silve as the landlord. He was the landlord, and the landlord, the son Diwan Shahi Manki, had settled the entire land to the present plaintiffs. That is the basis. उसी basis पे हम लेके आए हैं.
प्लेंटिफ के लैचेस के कारण नॉन सब्स्टिट्यूशन पर हम
नहीं ठीक है उस पर नहीं उसको फाइनली डिसाइड कर दिया गया. तो हम चाहते हैं कि यहीं सब जाए, अदरवाइज कितना वहाँ भी जाएगा तो वही.
सेक्शन 30 में आप क्यों नहीं गए? यू डिड नॉट अवेल योर रेमेडी. अब अलग से सेक्शन 30 तो आप हार गए ना.
हमको लगता है उसका कहीं हम देखें क्योंकि डॉक्यूमेंट नहीं है, देयरफॉर आई एम नॉट स्पेसिफिकली सेइंग दैट. लंबा जजमेंट हुजूर, एक बार हम उसको उस पॉइंट को भी हम देख लेते हैं, और इस पे अगर इनको जवाब देना है तो एक बार दे दें. और एक एनी opening week का first week of November में रख दिया जाए in final disposal, because only on that point I have to prepare myself, otherwise I am ready in the case.
इसके अलावा इसमें कौन सा
पॉइंट हुजूर यही है कि since the original landlord,
क्या सेक्शन 30 का क्या ऑर्डर था बताइए.
right, सेक्शन 30 आया है. उसको कोई फाइंडिंग भी नहीं है उसमें.
That amounts to a decree. Section 30.
Yes, that amounts to a decree. Yes. हाँ, पैराग्राफ पेज रनिंग पेज 17 में हुजूर एक जगह सेक्शन 30 का है. Not sure. May I read that? वादी ने अधिग्रहित भूमि पर स्वत्व निर्धारण हेतु भूमि अधिग्रहण की धारा 30 के तहत निर्देश के लिए एक लिखित याचिका दाखिल कर प्रतिवादी संख्या 1-2 से संपर्क किए, परंतु उन्होंने अवैध तरीके से प्रतिवादी संख्या 3-7 के पक्ष में स्वत्व की घोषणा की तथा अवैध तरीके से उन्हें मुआवजा भुगतान किया. That means I think it was not decided. आगे उसके बाद कुछ नहीं आया.
एग्जिबिट डी स्वार्थवाद संख्या 12/1997 की.
नहीं, that is different. वो दूसरा तो अभी का है, अभी का कंपनसेशन. वो एक और केस हुआ था, रेस जुडिकेटा पे सारा केस डिसाइड कर दिए. Therefore, I was praying with Honorable Court कि Lordship may decide the matter here.
ये सेक्शन 30 का केस नंबर क्या था?
यहाँ पे हुजूर कुछ नहीं लिखा, सिर्फ इतना ही आया है, इसके अलावा कुछ भी नहीं आया है.
नहीं स्वार्थवाद संख्या 12/76 से ही.
नहीं वो नहीं है हुजूर, ये तो अभी का कंपनसेशन है, जस्ट रिसेंटली.
76 रिसेंट तो नहीं.
एलए केस 17/10/11 का हुआ है. 10 अभी उसका ये हुआ है, अभी एक्वायर हुआ है 2010-11. Lordship, the case was filed by me. It is said by the.
Exhibit F क्या है? LA केस नंबर 17 of 2010-11.
हाँ, यही इसी एलए केस में अवार्ड हुआ है डिफेंडेंट्स को सारा कंपनसेशन of that they have received, against which Lordship this suit was filed.
Against suit, it is not an appellate remedy.
ठीक है. I'm aware Lordship. वो हम समझ रहे हैं. सेक्शन 30 का एक बार हम देख लेते हैं कि इसमें अगर कुछ फाइल हुआ है कि नहीं.
वही क्या है तो देखिए आप क्या. एग्जिबिट एफ है, एग्जिबिट रिकॉर्ड का आया हुआ है.
इस पे नहीं है वो एग्जिबिट ही नहीं आया है.
एग्जिबिट एफ नहीं आया राइट. जो काम का एग्जिबिट है वही नहीं आया.
नहीं वो हम नहीं कह रहे हैं. एग्जिबिट वो एग्जिबिट हुआ.
एग्जिबिट एफ दिख रहा है.
दैट इज द अवार्ड ऑफ. वो तो 17 एलए केस का 17 10-11.
हां 10-11 वही 10 ही.
एफ
एग्जिबिट एफ.
डिपेंडेंट. 3 to 7. After section 30 lordship proper suit that is decided by the sub-judge.
Yes, ये तो अजीब तरह का है तो वो
Therefore,
exhibit A is not that.
trial court lordship has decided the entire matter only on the basis of res judicata. सब्जेक्ट का कोई जजमेंट हमको दिखा नहीं और उसमें नंबर भी दूसरा पड़ा. The new act lordship the tribunal has been constituted, but in the old act it is to be decided. Reference has to be made to the subject.
Section 30 का भी reference इधर ही होना.
I think in LA case lordship the objection might have been given that the matter may be referred to proper court under section 30, but without considering the same lordship the order has been passed. That is what from those two lines lordship I could find out.
Plaintiff number, who died? Plaintiff number? Plaintiff, which plaintiff died?
Not sure.
At the time.
I'm just giving
Plaintiff
it.
number 4.
Shankar Mehta.
Shankar Mehta, lordship. The wife and the daughter now has been substituted. No, not substituted, added as well.
Yes, what is your instruction? What do you want to do? आपको तो कोई एविडेंस भी नहीं नीड करना. क्या करना?
इनका आर्गुमेंट को अडॉप्ट करना.
You have got nothing to say. Yes. The silence में मत देना. आपको क्या करना? What do you want? या absolutely clueless, आपको पता ही नहीं है क्या करना. बताइए.
शंकर महतो का डेथ हो चुका है ड्यूरिंग द पेंडेंसी में यहाँ पे ऐड किया गया था कि
ऐड किया है ना अभी सब्स्टिट्यूशन नहीं अलाउ किया है ना तो सब्स्टिट्यूशन नहीं अलाउ कर सकते बिकॉज़ यू डाइड शंकर महतो डाइड ड्यूरिंग द पेंडेंसी ऑफ द सूट. The co-plaintiff, he is your brother, full brother.
The full name, cousin, sub cousin.
Cousin, brother.
And sister same.
Did not take any step for substitution. Now he said that the decree is a nullity. और जिनको अपोज करना है वो गायब. Mr. Satish Keshri is absent.
He is very punctual. He always he was here in all the times. Must have some problem. I must confess, lordship, in all the When the date was there, Lordship, he was there in all the date. Earlier dates, Lordship.
और सबसे बड़ी बात है जो लीगल हियर्स हैं शंकर मेहता दे आर नॉट द अपीलेंट,
They are not.
दे आर नॉट एग्रीव्ड,
हाँ वो उन्होंने फाइल नहीं किया only when the
दे आर नॉट
stamp.
एग्रीव्ड
हाँ
एंड यू आर
yes.
एग्रीव्ड.
हम भी एग्रीड नहीं हो सर. हम चूंकि this is a technical matter, therefore हम.
It is not a purely technical matter. They are not agreed.
They are not agreed.
You are agreed.
हम
तो
agree.
उनका सब्स्टिट्यूशन आपने नहीं किया तो नलिटी हो.
नहीं हम एग्रीड नहीं है. हम हमारा ये कहना है कि इसको मेरिट पे भी हुजूर डिसाइड कर सकते हैं. That is what my submission is. It is absolutely upon the discretion after adding them as party because it will cannot be said by them.
Then they should file an affidavit.
Yes.
That they don't intend to use any evidence. Then maybe
Whatever this way or that way, Lordship, they can file. If they want, they can. Otherwise, they will not.
As for them, we will not pass any order to that effect.
Yes.
उनको कुछ समझ ही नहीं आ रहा.
I'll explain. Because one thing is there, we just have to point out, all cousins are there, and the wife and the daughter was the heir of Shankar Math. It happens in the family. Compensation तीन ही भाई लोग को मिल जाए, चौथा को ना मिले. If some degree is passed, to be very fair, हम उस point पे अभी I just got it because only daughter and the wife is.
LP number 4, sorry.
First.
First LP number 136 of 2024. The learned counsel for the applicant has submitted that Shankar Mehta, a co-plaintiff, had expired during the pendency of the suit. His wife and daughter have been made party in the present proceedings who have appeared through a counsel. The learned counsel has submitted that the decree against a dead person is a nullity. However, he does not dispute the fact that otherwise the interest of Shankar Mehta was same as that of the other two plaintiffs. The learned counsel for the legal heirs and successors who have been made party in the present proceedings as respondent number, who have been added as party in the present proceedings as respondent number 8 and 9. Also prays for adjournment to seek instructions as to whether they wish to leave any evidence over and above what has already been placed on it. Nobody is appearing on behalf of the private respondents.
Better Lordship 5, 6 and 7. You be private.
Respondent number 5, 6 and 7. An IA has also been filed seeking to adduce additional evidence through IA number 10979 of 2025. Close this case on 24th November. In the meantime, the respondent number 7 and 8.
8 and 9.
8 and 9 shall also seek instructions. And the reply to the IA be filed by the contesting. तो सब कर दिया ना?
हाँ, बिना सब. Right.
Item 19, first April CT2 of 2025.
I verified recording in the judgment about registration in Calcutta is wrong. The document is registered in Ranchi, and the power of attorney on the basis of which the deed was registered, that was registered in Calcutta. So that is not illegal. Because
So why is it mentioned registered in Kolkata?
it has been mentioned, but because the power of attorney was registered in Calcutta, and therefore probably that observation. Twice at two places, Your Lordship would take note that earlier also this, with regard to another fact, this wrong recording of fact was there, and this is also there. And it is there before Your Lordship, the document is there.
And what is the evidence regarding matching of that?
Matching with regard to R.S. Khatyan, it is not there, but C.S. Khatyan and C.S. Kevat was there, and it was there, and this was never an issue. Therefore, I don't know.
No, it was never an issue.
But Your Lordship, C.S. Khatyan and Kevat both were there.
Kevat is also relatable to C.S. Khatyan.
Yes.
So how do we get it? From where do we get that this is the corresponding property? From where do we get this? Because this chain has to be established. And it is not a case where they denied it. They did not deny in the written statement.
So, may I pray one thing, Your Lordship? Because I have seen that in your the trial court has not sent two documents to Your Lordship, to this honorable court.
Which one? Exhibit?
These are C.S. Kevat and C.S. Khatyan. 3 and 4. Exhibit 3 and 4.
Exhibit 3 is CS Khatyan. 4 is the Kevat.
It should have sent. I don't know why. Because it was filed and it is already there in the record, and it is not. It is not there in Your Lordship's record. So
and
this
the
is
court
not.
Also says that there is a photocopy only filed.
Photocopy
of the deed.
No, it says that certified copy of it. Certified copy of.
Photocopy of certified copy.
Photocopy of certified copy.
Page number
वो तो wrong है, वो तो wrong है,
70.
वो certified copy का ये तो फाइल है.
आपने तो निकाला नहीं है ना, आपको निकाला होगा तो सब्स्टिट्यूट किया होगा.
नहीं एकदम नहीं, वो कहीं नहीं.
तो ओरिजिनल रिकॉर्डिंग मंगाते फिर क्या करेंगे? Then we'll call for the original record.
हाँ, Your Lordship, yeah, absolutely. Your Lordship क्या?
While going through, although the case was listed for further dictation in this case, however, while going through the records, the learned counsel for the appellant has submitted that Exhibit 3 and 4 has not been forwarded by the learned court along with the records. He has also submitted that it has been wrongly mentioned in the impugned judgment that the plaintiff had only filed photocopy of certified copy of registered sale deed dated 23/5/2016. He has also submitted that it has been wrongly recorded in the impugned judgment that the deed was registered at Kolkata. He submits that the original records be summoned at the cost of the applicant. Considering the submissions, let the original records of the case be summoned. Upon deposit of special messenger caused by the appellant by day after tomorrow, you will submit the cost. Cost for special messenger.
Cost whatever you know.
थोड़ा सा लगता है 100-200 500 रुपए
I'm not aware about cost. Whatever.
cost for special messenger cost
हाँ जो भी
रांची का है
होगा
ना
हाँ एकदम स्पेशल मैसेंजर रांची का
रांची का है यार
whatever cost is there that would be reported by the office and
वो रिपोर्ट करते हैं क्या
उसमें जो भी कॉस्ट होगा उसका कुछ होता है
ठीक है तो हम आपको थोड़ा ज़्यादा टाइम दे देते हैं by 16
ठीक है And in my evidence, I've said
4.29
that Nibanthit Kewala ka Japta Nakal. I don't know what Japta Nakal certified. हाँ certified.
आने दीजिए ना रिकॉर्डिंग ड्यूट ऑर्डर में जब ऐसा लिखा हुआ तो क्या करें
नहीं ठीक है मिला लिया
वो एरर को तो रेक्टिफाई बिना डॉक्यूमेंट देके तो नहीं कर सकते
ठीक
29th
as
ओपनिंग डे
2-3 दिन बाद
30 तारीख
हाँ ठीक
30 तारीख
Item 20, first April 70 or 2025.
Compliance to the lordship's last order was my case compendium and my list of date was that is ready. As I was praying because that as Mr. Pallam he cannot assist your lordship in any private matter because it may be a short adjournment may be given because so that was a note also has to come from the side of the respondents.
what has to come
A note if was it so
We have already filed the returns.
copy has not been served upon us that matter.
you provide us the soft copies
The returns.
Word document was on PDF.
sorry
The Word document.
what document PDF also
Both will be given.
yes because we take certain things from your
Let's
submissions
immediately
also.
today itself not in the evening.
The learning council for the parties are present. They are furnished the written submissions. आप उनको दे देंगे आप
Just lots is given me. I have also given you.
after exchanging amongst themselves. It will certainly be open to the parties to point out any submissions made through the written submissions which are beyond the records. If you do not point it out, I take it that it is based on record. Okay, you go through it. There could be some statement beyond the records. Okay.
The notes are based on the same submissions which were made before 1400 time.
That opportunity has to
Yes.
be there. The learned counsel for the appellant has submitted that the case was to be argued by Mr. Prashant Vallabh since he has become the ASGI. Therefore, he is unable to argue this case. Alternative arrangement is to be made. When will we do it? When?
First week of December, by first week of December.
The learned counsel has prayed that the matter be posted in the first week of December. Any objection?
Your Lordship, we have already filed an IA for additional evidence. Order 41 from 27.
That copy is also not being served upon.
A petition under
Yes, that is mentioned.
a petition seeking to adduce additional evidence has been filed through IA number 11891 of 2025 by the respondents. Learned counsel for the appellant has submitted that he shall file a response to the suitability application. What happens in a case where the initial evidence is allowed? Do any further opportunities required to be given? Yes.
Yes, in case of rebuttal, if the document to be adduced or any evidence to be adduced is such nature that a rebuttal is required, then the other side is given an opportunity. Otherwise, because what we have sought to be adduced is a judgment.
No, I'm not talking about this. In case there is additional evidence and opportunity is given.
To rebut.
Just a response to the interpretation application. Parties dispute. Then under such circumstances, any further opportunities required to be given?
No, if the evidence sought to be led is of such a nature that it requires, the document requires to be proved, then in that case the court is satisfied, yes, this evidence is required, then it is either, since it is the first appeal, this court has the power to take evidence, else it is remanded. It should be remanded.
To take evidence on that and then return it to the court. Anyways, you respond to this interlocutory application. Post on 8.